what really happens when a marriage breaks down? Recently, I have been having cases where I serve a lot of divorced couple that they are selling. Not that we are advocating divorce, but because our society, we have more and more divorce cases rising, right? Not just in Singapore, but all over the world. Hence, today I actually invited a former property lawyer turned real estate consultant, Jason, who will share with us, right, the step-by-step of a divorce proceeding and what to look out for if you are really going down this path. So we have here with us Jason.
Hi everyone, Jason here.
So without further ado, we'll straight dive into the different stages of divorce. So before you even reach the stage of selling your property, right, maybe let us first understand, because on the ground, right, I do have a lot of clients that ask me, hey, does my ownership structure affects how the divorce proceeding will be when I sell my house in the future? Because I understand there are a few ownership structure like tenancy in common, joint tenancy. If you don't mind, Jason, can you explain the difference?
Sure. So generally in Singapore, there are two ways to own the property, either joint tenants or tenants in common. Joint tenants, very simple. Both parties own the property as joint owners. They both own 100% of the property. If anything happens to one of them, i.e. pass away, the other party will just carry on remaining as the sole owner of the property. The other manner of holding would be tenants in common. Tenants in common, you allocate shares to each party. So currently in the market, it's very common for parties to hold the property as 99-1 so that they can actually structure their property portfolio in future, taking into account the intention perhaps to buy a second property.
Oh, so like decoupling, the legal way of doing the 99
Yes,
one,
yes.
the illegal way. We don't do the illegal way. Okay, then comes that question, does it affect divorce, the manner of your holding?
Okay, so contrary to popular belief, actually the manner of holding does not really affect the splitting of the matrimonial assets when it comes to a divorce. Instead, the court will actually take into account what is the direct and indirect contributions of each spouse, each ex-spouse, and allocate accordingly the total pool, the total asset pool, and from there they will see how to allocate the assets to the ex-wife and the ex-husband. They also look at perhaps who's having custody of the child and which is the most convenient way to affect each party's life, especially the child's life, the least.
So there's no way to upfront determine how much share I'm going to get, because it's not for us to decide, right? Once they go into court, it will be for the court, family court to decide already.
Yes. Of course, there's also another way to look at it. There are some marriages, before they enter into the marriage, they do a prenuptial agreement.
Oh.
So if they do a prenuptial agreement, then the family court would actually take into account the prenuptial arrangements in the agreement.
But that's usually if one party is very rich. Okay. Common thing that I face on the ground, right, is usually when I have like couples that are going towards the end of their marriage, for lack of a better term, they will always ask when should they go and consult a lawyer, or when will the lawyer determine when is the best time to sell the house, or is there any other way around it?
So in terms of divorce, you have a few types. You have the contested divorce and the uncontested divorce. So uncontested is the simpler one, as the name suggests. Both parties agree to divorce amicably, and in this case, sometimes if it's so amicable, the parties can even go to the same law firm, just that they will still be separately represented to just handle all the post-divorce paperwork.
Is that the cheapest alternative?
That is the cheapest alternative.
Okay.
Yeah, there are many law firms out there which they will do package deals for very straightforward uncontested divorce. It's actually much cheaper than one would think. Then of course there is the contested divorce, where then both parties would definitely be appointing their own law firms to represent them and to best present their interest, their side of the story to the family court, so that they can perhaps get more of the matrimonial assets division at the end of the day.
Okay. So usually when the divorce proceeding happen, right, this is after the before stage already, what happens to the property? Do they still continue to stay inside, or both of them have to move out? Is there any like standard rule for that?
So there's no rule for this. Both parties can still be living in the same household. They could be sleeping in different rooms, or one party, if it is an acrimonious divorce, one party could have moved out, returned back to the family's homes. So there is no hard and fast rule. There's no requirement for parties to move out during this process.
Then for the mortgage or expenses part, assuming there's still outstanding loan.
These will definitely still have to continue to be paid.
Okay, so if they are not on talking terms anymore, then they will have to speak through their lawyer to get it done.
Yes, either they speak through their lawyer or they just carry on whatever is the arrangement. But of course, it's important to take note that all these, if let's say we are looking at a divorce, ultimately the financial contributions from both parties, if you have more records, that will be more helpful to your case.
Okay. Then, because I have cases, right, just based on my experience, I have cases where one party don't want to sell, like die don't want to sell, whereas the other party just want to sell and move on. How would it affect the overall sale of the house, or is there anything that can be done to get the house sold?
There would be some delay, but it can definitely be circumvented, because if one party don't want to sell, despite the terms of the sale being very clearly stated in the order of court, then you can actually apply to court to get the registrar to be empowered to sign whatever is the necessary documentation to push through with the sale.
Because there are cases where, like I'm serving both the husband and wife, and one party just want a ridiculously high price just because they don't want to sell the property, and their reason to me is, oh, I want to sell, but you cannot get the price I want, so we continue waiting, lor. And because of this, it costs so much headache for the wife as well, right? Because she's still staying in the house with the husband, and we just cannot achieve that sale price. Is there something that can be done with regards to that?
Yes, then both parties can actually go through their lawyers to come to a conclusion as to what should be the acceptable price range, based on perhaps 3 independent valuers being engaged to decide on what is a fair price. And then as long as the agent is able to hit this fair price, then the property can be sold.
So if that market value is out by the 3 independent valuer already, and one party still refuses to sell, the registrar will sign on the person's behalf.
Then you have to do the necessary applications through the law firm to get the registrar to sign the necessary documents.
But correct me if I'm wrong, because this sounds very messy, and like when you go through these kind of things, it's always draining and it's a very tedious and long process, right?
And expensive.
How long? Yeah, that's why just go for the cheapest option. Both of you agree and have an uncontested divorce. But how long does this proceeding take from the moment, let's say, they want to contest on the sale price or whatsoever? How long will it take for the whole thing to be finalized or settled?
So I would say there is no hard and fast rule, right? Because at the end of the day, it depends on, firstly, how fast your lawyers work. Secondly, how quickly both parties respond to each other. Thirdly, how quickly the valuers are engaged. The valuers can be agreed upon, because it could be the husband appoint one valuer, the wife appoints one valuer, and we take the average of the two. So there are many different factors. It's a bit challenging to say how quickly or slowly this entire process would take, but I would guess that it would be at least a couple of months.
Okay. From my understanding, for all the past sales I've done, I understand there's interim judgment and there is final judgment.
Yes.
Usually, when will be more advisable to take the step into marketing your unit for sale?
So once you have gotten the interim judgment, and assuming that your ancillary matters, i.e. how the property is to be sold, at what price, how is the proceeds to be split, whose CPF needs to be refunded by who, and so on. If once all this has already been settled, then perhaps that's when you can start looking at interviewing agents to see which agent would best suit your needs for both parties, whether you all want a joint agent marketing or each of you want your own agent to market the unit. And then thereafter, of course, for the entire sale to go through, you need to wait for the final judgment.
Okay, so it would be best that you start to look out for agents to market your unit and only start the marketing after the final judgment is out, because you have settled all the costs and expenses and that split lah.
Just to add on that last part to your question as well about the interim and the final judgment, the reason why we can already start engaging agents, to kind of maybe take photos and even prepare to market the place is also because typically your final judgment is issued 3 months after the interim judgment. So that's about a nice time that you can have time to find the agent and let the agent do their work. One of the common things that I used to see when I was practicing and we were doing all the completion accounts is how do you actually split the sale proceeds based on, even if let's say the court awards 20-80% split or 30-70, 60-40, how do you actually award fairly such that both parties would feel that the way that the sale proceeds is calculated is fair? So for instance, in a $1 million property, let's say the outstanding bank loan is $400,000. Then you have a balance of $600,000 to be split among the parties. At the same time, your CPF usage would not be the same for both parties. Let's say one party didn't use CPF, the other party used 100K worth of CPF. Then you minus another 100K from there. Then you have 500K left. So this 500K, that means that at the end of the day, this 500K gets split according to the percentage awarded by the court. Because in my opinion, that's not fair, because at the end of the day, the CPF that one party used should be regarded as part of his share of the sale proceeds. Of course, again, it ultimately depends on how the order of court is drafted as well, because there are some order of courts that are very specific to say how the sale proceeds are to be divided, i.e. they will say your total sales proceeds less the bank loan outstanding, less party A and party B's CPF usage, and then finally the balance is split as to what percentage. If you have that, it's very clear.
I saw one that go into specific as in how much percentage of agent commission they are paying, legal fee, how are they going to split.
Yes, even property tax, they could also be even having a
But
percentage.
upfront, they need to go the divorced couple need to go into all these details to be
Yes.
as specific as possible. Like, if
So
they're really in the
yes,
kind of
so it depends on how acrimonious the divorce is, how particular each party is as to the splitting. Yeah, because some parties, if they are more easygoing, you don't actually have to go down to fine combs all these different payments. But if let's say it's not it's somebody who's more particular, then of course every single line item, even down to utilities bill for the last month, they may even want to have that stated also.
that's the thing with a divorce sale, which often is hard if both parties are not on talking terms, because sometimes it's not for that money, it's just 为了一口气 so it tends to get more emotional and the emotional is not from love, maybe it's from a place of love, love turn to hate, but that 一口气 will make things very difficult for the agent selling or the lawyer that's representing them. Because I do come across recent divorce case which I did, right? They really go down to the dollar and cent, and the sale fell through because they couldn't agree, right, who will pay that maintenance fee.
Agent pay.
Yeah, which and the other one is which I did recently is the deposit of the 1% for the OTP for a private sale. So the 1% they want to split, but both of them couldn't agree because the husband wanted a much bigger share, which was not allocated in the court order, and it's not specific. Then the husband don't want to sell because he cannot get a certain amount from the 1%. And it's not like the 1% is a lot. The 1% is only around $12,000. So I think he just wants 10-20% more. But the whole deal fell through because both of them couldn't come to an agreement on this 1% deposit. So, which brings me to my next point, right? Which is, as a lawyer, are there any way out rather than just selling the property? If, let's say, I just buy over from you, I'm the wife, I just buy over from the husband, can that be done?
Of course. So there are many orders of court. It's never just about selling in the open market. There's also many cases where, let's say, the husband perhaps has a new girlfriend and would like to exit the house, but at the same time, for the love of the ex-spouse and the children, the husband is willing to let the ex-spouse carry on living in their previous matrimonial home. It's just that the ex-spouse will of course want to be paid for it. So at the end of the day, the order of court can say that ex-wife or ex-husband is to transfer his share of the house to the ex-wife, and ex-wife is supposed to pay ex-husband X dollars or refund the ex-husband CPF.
So the X amount need not be at market value, correct? Because it can be negotiated amount. Let's say the ex-husband did something wrong and just feel very bad for the wife, and the property is 1 million. He say, okay, I will just sell it to you for 200,000.
Yeah.
It can be.
It wouldn't be selling to you for 200,000. So it would be because, like I mentioned, because the ancillary matters is looking at all matrimonial assets as a whole. So it could also be that perhaps because the ex-husband got the full value of the car, and then the ex-wife got the full value of the house, then there's a net off difference such that the wife needs to then compensate the ex-husband so that he doesn't feel shortchanged.
Oh, okay. So
it's always like a total pool, and then from this total pool, the court will apply a very broad approach of items A, B, C, D, E goes to the husband, items C, D, E, F goes to the wife, and this total value add up to how much. This is roughly accounting to 40% and 60% of the value of the assets.
Are there cases where like one party just willingly give up the entire property?
Oh yes. I mean,
so it's more of a transfer of shares already.
It's like I'm just gifting it to my ex-spouse as a parting gift for the marriage.
But even gifting, there's an issue. Does the ex-spouse need to take over the existing mortgage and pay the stamp duty?
So the ex-spouse will definitely need to remortgage the entire house because currently the mortgage will be under the joint parties' names, right? So the ex-spouse, when take over the whole house as a sole owner, they will need to redo their mortgage all over again so that the mortgage is under one name. Yeah, but of course it also varies from bank to bank, because I have seen before there are certain banks who will just allow the one party's name to be removed from the mortgage and then for them to carry on the mortgage as it is. And this is because some parties, they are not willing to remortgage their house because then they'll be under the new interest rates package, which may not be as favorable as what they first signed up for.
Okay, back to this point. What if, right, the person they want to take over is not working? Then they have no choice to take over the loan, right? They'll still have to sell it, right?
Yes. So, of course, practically, the court can order one, but it also, at the end of the day, depends on practically whether you are even able to take over the property or not.
Financially,
yes, financially.
But what about stamp duty? If they do a takeover like this?
There is no stamp duty if, let's say, you are doing a transfer of the property pursuant to a divorce, and if, let's say, the asset is transferred to within the family nucleus.
Okay. So stamp duty is
we have relevant. We have a remission provision that allows for stamp duty to be waived in such cases.
The last point to this, right, is I understand that for final judgment, okay, I've seen a very weird final judgment before. There is no timeline for the sale of the property. I'm not sure whether you have seen such case, but I have done one. There's no timeline. Maybe because it's not the Syria court, is it?
Syria.
Yeah, Syria court. So I was serving this Muslim couple, and their final judgment, there's really no timeline. So it took them like 2 years to sell because the husband keep backing out. Of course, this is quite rare, but most final judgment, there will be a stipulated time for you to take action to sell the property.
Yes,
right?
yes, there should be, because otherwise there's no pressure, there's no time pressure for one party to quickly take over the property and then the other party will not be able to move on.
How will the judge determine, okay, let's say if I really try my best to sell my property at market price and I couldn't sell within that stipulated timeline of like 6 months, how would the judge determine whether is there extension given or...
So normally, actually, the timeline is not like a hard stop deadline where if you don't do it, you need to go back to the court. My understanding is that let's say the court typically gives you 6 months. If let's say you sell it at 6 months and 2 weeks, as long as both parties don't make noise, the whole matter can just proceed as it is. Of course, it is when one party feels that the other party is not trying hard enough, and that's when parties want to go officially go to the court and get an extension.
Okay, so usually the timeline is not fixed, but it's more up to both parties. If both parties are doing their part, then it's fine. It's usually like if one party is really unhappy, then they will go to the lawyer, go to the court again, then force the other party to do certain actions. Yeah. Okay, so I think that is all for the legal part of divorce. But back to something more practical. Have you ever dealt with divorce cases, and what are the things that will always hinder you from the sale of the property or anything?
So like you mentioned before, right? If let's say for divorce cases, usually it is one of the ex-spouse trying ways and means to make it difficult for the other party to exit, for the other party to sell the house, because either the price is not right or they make viewings very difficult. Yeah, ever had a case before where both ex-spouses appointed different agents, and then there was a very hard time for the ex-wife's agent to be conducting viewings, and finally, even when getting an offer, the ex-husband agent will also claim to have an offer, and then it led to both agents appearing with both ex-spouses at the table of the law firm, so that the lawyer is the neutral party who will then look at the offer prices of both parties, and the house will just get sold to the highest bidder. Yes.
But
so there were a lot of mind games involved.
If you appear before the lawyer will still charge you a fee. So you are paying.
Sure.
And it's not cheap because you're paying commission on top of the legal fees.
Yes.
Yeah, this is what I usually encounter as well. The ex-spouse, both of them each have their own agent. And there's no issue to it, right? If everyone is working towards a common objective.
Yes.
But usually in divorce cases, at least for the ones I've seen, I would say majority of them, they would always want their agent to take their side. So it's like the ex-wife will engage their own friend or whoever they know.
Yes.
The ex-husband will engage whoever they know. And they are not working together to sell the property. Because if you look at this whole thing, taking divorce aside, it's just trying to sell the property off so that even though things didn't end well, but at least you all can move forward. But most of the cases that I've seen, they are still harping on it because they have their own agenda, or they are trying to protect their own
own interest, their own ego. So their own ego could be they want to be the one who sold the house. They want to be the one who found the highest bidder. Or it could also be that I've encountered before is that actually one of the ex-spouses is not ready to move yet. That's why he's not in a rush. So therefore, there will be a lot of hindrance from them in terms of viewing not free, or in terms of price is not what he wants, and so on.
Yeah, that's the main challenges which I face. But over the years, when I come across cases like this, I become more sing. Like the first thing I will always ask is, for myself at least okay, for those out there that are going through the divorce process, if you can find someone that is neutral, unrelated to either the wife or the husband. Why so? Because then you all can sit down and talk about the objective of the sale of the property. Objective is very simple. At what price do you want to sell, and what is the timeline you need to meet? That's all. And whether you need extension or not, and how the sales process is going to be, and whether you can plan for your next purchase. If you all choose to still have your own agents, right, at least have the agents and both parties coming down before the sale even starts to talk about how things are moving forward. Because you don't want it to be a case where one of the most common issues I face is I become a messenger for one party. Then when I deliver this message to maybe the ex-husband will come and gun me. Thought I'm representing the wife. Then I go back to the wife. Then the wife will gun me because I am supposed to go and gun the ex-husband. Then I'm just the middleman. But my job there is just to facilitate the sales. So I feel it will be easier for both parties. No wrong if you want to engage your friends or family members to sell for you, but at least whoever is involved in that sale, right, other than the main party, the agents come together and see how we can work together to push the sale forward. It can be even the case of, which I did, and many people will not believe me. I called the ex-husband agent. I say, whoever closed the deal, we just split the commission 50-50. We treat it as a co-broke case, but at least we get this done. We are not out here to take either party's side, even though we know each other clients personally. We are just here to facilitate and move on. Whatever disagreement they have in the past, we'll just leave it in the past and we will just focus on our objective now, which I feel is a more forward-thinking way.
I think it's also more beneficial to both parties, because if the two parties' agents, I mean, both parties elected to use their respective agents, but if the both parties' agents being neutral to all this acrimony and all that, they can come together to then market the unit together to move towards a closure. It is beneficial for everybody. Beneficial for both parties to move on, beneficial for the agents because they are not actually in direct competition with each other as well. You know, so I think it would be much more helpful towards the couple.
Yeah, that's what I feel also, and that's what I learned, because last time when I was still a new agent, I tried to 做的和事佬, but most of the time I wound up in their whirlpool of emotions and I get very drained after that. I just say I don't do the sales. But now as I start to learn and experience more, I find that this is a much better way moving forward lah. So in any case, I hope that this video today, right, answers I would say the most frequently asked question regarding divorce. And if you do have any more questions, or if you're thinking or in the process of a divorce and you need more professional or legal help, always look out for Jason or me, or just look for a lawyer lah, to get all points covered first, rather than listening to your friends or relative, because they will always be taking sides lah. And just have a more neutral approach as we end off this video. Do you have anything to add on?
Yeah, I think just to add on to what Sherwin mentioned as well, I think it's really very important for you to seek legal professional help when this situation occurs, because a lot of the times we are always turning to our friends and family first to ask them. Of course, you can definitely ask them if, let's say, they have experience going through all this as well, but it's still most important to get legal professional advice, because sometimes whatever you hear from your friends and family, where the intricacies of the divorce is concerned, would be more. It will be clearer if, let's say, you seek all these advice from the right parties.
Just don't ask ChatGPT first. Just go to a lawyer, ask for some professional advice, because we have a lot of people asking ChatGPT nowadays, and they come and debate with us. Hey, ChatGPT say this, ChatGPT say that, but no, ask a professional.
Or at least try marriage counseling maybe.
Oh yeah. Okay, so don't divorce first. Try to work things out first. Even if you don't work things out, at least you can have an uncontested divorce, right? It will save you so much more money.
And also a lot of mental stress that can be saved from the experience.
Yeah, so if your love is no longer there, at least your money is in your pocket lah. So that's all for our video today. Thank you for watching, and remember to like and subscribe.
Thank you.